Hi everyone, I'm Kyle Bechet, and this is the AAF Exchange, a podcast from the American Action Forum, where experts provide clear, data-driven insights into today's economic and domestic policy issues. Welcome, and thank you for tuning in. Jeff, welcome back on the podcast. Thanks for coming on. It's been a while.
Thanks for having me. Yeah, I'm excited.
Yeah, I think the last time we had you on was maybe Live, when we talked Live, or maybe there was another time after that, but it's been a while.
Been a while. That Live one was fun, though.
That was a good one. Everyone should go back and watch that, just for a quick promo.
Especially as we have the Masters coming up.
The Masters is coming up. It's, 2 weeks away? Something like that?
I think it's the further,
I think it's like maybe 3 weekends away. But how's your bracket doing? That's the real question.
You know, it's doing all right. The important thing is the Arizona Wildcats are still doing well, and they're playing Clemson tonight. So, well, I guess maybe not night for people listening, but night for me recording. So I'm looking forward to that. And hopefully, as you're listening, the Wildcats have moved on.
Well, you're certainly doing better than me in the bracket pool. I think everyone in the office on Monday was equally as happy that they're doing well that I was in last place.
I can't stress enough how much the point of this office pool is to see Kyle lose and not for anyone else to win.
Yeah. All right. Well, should we actually do what we came here to talk about?
I mean, I do like basketball.
All right, let's do the intro. On this episode of the AAF Exchange, a deep dive into the Department of Justice's antitrust lawsuit against Apple, the key arguments, and potential implications for consumers. Joining us to discuss all of this is AAF Director of Technology and Innovation Policy, Jeff Westling. Jeff, thanks for joining us.
Thanks for having me. So
let's just jump right into it today. We want to do a good deep dive into this topic because I think it's in the news right now, and there's a lot of people are talking about it. So the Department of Justice filed an antitrust lawsuit against Apple. First, walk us through the big picture of the DOJ's case here.
Yeah, well, I think it's important just to take a little bit of a step back in the big picture of the approach of the Biden administration generally to antitrust. And this isn't really a new thing that we're seeing. The DOJ, the FTC, both have been bringing a lot of cases recently, and they've been going after a lot of the big tech companies. Obviously, Google's has, I think, 2 lawsuits against it right now. Their search engine practices and also their ad tech business. Amazon's been sued. Microsoft back in the day before the Biden administration, but that company has been sued as well. And even Meta, with some of their mergers, has been under scrutiny from this administration. And what it stems from is this larger concern about concentration in technology markets. And I think the Apple case is just kind of the next step here. And it's also not the first time Apple's been kind of under scrutiny. They were sued by Epic, another company, rather than a government enforcer, alleging their App Store practices have violated the antitrust laws and essentially, charging too much for application developers and not letting them kind of bypass some of the fees that are in the store. So this is kind of the next step there. The Apple more or less won the Epic case. So now the DOJ is kind of bringing a slightly different case that's targeting smartphones generally, and it's basically alleging that the company is just monopolizing these markets and doing so in anti-competitive ways.
Interesting. But all right, so let's just jump into dive a little deeper into the allegations being made here in this specific case. What are the DOJ's main claims to assert Apple has this monopoly power?
Well, let me take another step back and just kind of lay out what the DOJ needs to prove, because there's 2 key elements. First, they need to show that Apple has monopoly power in a relevant market, and that means that Apple would have the ability to exclude rivals or control prices in some distinct market. And that's the first element, and that's kind of what your question is getting at. What are they doing to show that they have that power? We'll get into this in a bit, but they also must show that they did so through anti-competitive means, which means Apple didn't acquire that monopoly power, that ability to control prices, exclude rivals through just out-competing, right? Like if you have a better product, if you've got better business acumen, if maybe you just got, my favorite word in the Supreme Court was historic accident. You just lucked out and everything kind of came up Milhouse as to turn a phrase. But so to your question, what are they alleging on the monopoly power side of things? They're essentially alleging there's 2 markets. The first would be this performance smartphone market, and essentially what the DOJ is trying to do is to narrow the market down into something that's small enough that Apple would have such a large share that of course they would have the ability to control prices. But it's not so much about what Apple has in terms of market share, but it's about what customers see as substitutable products, right? What can a customer go to if you try to extract those monopoly rents? So in this performance smartphone market, essentially, the DOJ is alleging that these high-end smartphones with a lot of computing power, a lot of memory, the high-end cameras, those kind of things are a distinct market because customers want or need those features. And if they can't get those features, they're essentially locked into those phones. And for that market, the DOJ asserts there's a 70% market share, and they're also durable because there's just frictions for customers from switching. If that performance smartphone market doesn't sell the court and say, hey, no, even if I can't get a performance smartphone, I can still get maybe a cheaper smartphone and it's a replaceable product. The relevant market there would be just smartphones generally, and that's kind of the other market asserted, in case DOJ can't prove the performance smartphone market, and that's a lot tougher for the DOJ to show that that Apple has monopoly power because there's just so much more competition at that level. And I think Androids have like 41% of the market there. And a lot of people like the open nature of Android devices. So I think that's going to be kind of where the DOJ goes with this. And Apple, for its part, is going to try to do the exact opposite, where the DOJ is narrowing the market, trying to be as small and as narrow as possible. They're going to try to broaden it as far as they can. I don't know if they'll do this in court because I'm not sure the court will buy it, but they'll probably try to expand this all the way to just flip phones, right? If if Apple has raising prices too much, they're making the service not as good as I would like it, and I just need a phone, I could theoretically go buy that.
Right.
And that's what we're worried about here. What we're looking at is whether customers can go find another product, because if they can, then Apple can extract those monopoly rents. They don't have that power to control prices or exclude rivals.
So basically, it's where the market starting point is. Is it when you buy the phone, or is it when you have the phone? And what is that sort of what it's getting at, or is it something? Is a little bit? I mean, obviously more nuanced than that.
It's a little different. I think the thing to understand is that it's whenever somebody's going to buy a phone, that is kind of what we're looking at. I think one of the key features here is that a lot of what the DOJ is claiming stems from the fact that they are saying the market power that they have, the market shares that they have, are durable because of the anti-competitive practices that we'll go into in a little bit, add switching costs. Yeah. So basically, the assertion is that maybe you have a 70% market share for high-performance smartphones, and you've got a locked-in customer base. Well, if the customer base wants to go get a different smartphone, they're saying Apple has put in these practices that make it hard to do that. Maybe I can't transfer my contacts. Maybe I don't like these. There's no way for me to use my Apple Watch with this other smartphone, so I'd have to get a whole new watch.
So it's getting out of the ecosystem.
That's a big part of this case.
Right. Yeah. Interesting. So you mentioned those anti-competitive parts of this. What Apple practices has the DOJ said are those anti-competitive practices?
So there's two main things at a high level, but they kind of go into different components, and I'll break it all down. But just at a high level, there's these unfair practices within the App Store that basically limit developers' ability to add these applications that would essentially have cross-platform functionalities. They use the term super apps, which are just like maybe you have phone, texting, payment all into one app, and if you have that in an app and it's on an Android device, it makes switching easier. And they're saying a lot of Apple's practices restrict the ability to develop and use those apps on the iPhone. The other kind of big picture topic is limiting cross-platform functionality of their devices. So things like the Apple Watch, right? You can't use an Apple Watch on like an Android device, and they're saying, hey, if I could do that, the switching would be a lot easier, and that would break into Apple's market share, and that's something that they're alleging is an anti-competitive practice and not one that's pro-competitive. And the other thing that's made all the headlines is those green text bubbles, the Android green text bubbles, and essentially saying that like, if I'm going to buy a new phone, I don't want the social stigma, and I just laugh at that. The social, and I'm not prejudging the case or anything, but I just love the idea that people are like, well, I just cannot go buy an Android because what will my friends think? And there is some truth to that. Like, I don't buy it, but maybe that's because I'm not, you know, a middle schooler still.
I mean, I don't think it probably rises to the level of a legal argument, but, you know, there is always that one friend that's in the green text bubble that you're kind of like, you know, just joshing around
Can
with.
we just move him out of the group chat so we can
get
our gifts back and our thumbs up without saying this person liked it?
Yeah, when it says, you know, you have to read it out. It's a small point, but I mean, it's an interesting one that they're actually including that in a legal argument.
Yeah. So if I could just circle back and just kind of like lay them all out. The super apps and what the other one for the App Store would be cloud gaming. Basically saying we're not going to allow a lot of cloud gaming apps because we want customers to rely on our hardware. Cloud gaming essentially allows you to run a game over the cloud, which means you're using computing power off your device and you don't need the high-end phone. So essentially, if you're limiting access to cloud gaming, then you know you're making people rely on your high-end iPhones. So we have the texting and the Apple Watch, and then the last thing they're looking at is the digital wallets as well, which are kind of limited to the Apple devices.
Interesting. You know, Apple has made a few public statements about this issue, on this issue, but how might the company respond to the DOJ's allegations?
So we already talked a little bit about the monopoly power side of things. They're going to try to expand the market. That's the number one thing they're going to do, and say, look, this isn't a performance smartphone market, because if we try to act like monopolist, the consumers are going to go elsewhere. Look what all else they can buy. Look at the other the phones that they can get. And when that happens, we can't actually extract those rents. So that's number one, and they're going to do that for sure. But when it comes to the anti-competitive practices, what they're going to essentially say is that all of the stuff we are doing is not to exclude rivals. What we are doing is trying to improve our product and improve our services for customers, and essentially make it so our rivals have to try to keep up. Like that's just part of doing business. And the Supreme Court and lower courts generally have all said you don't have a duty to deal with your rival. A lot of this stuff is kind of this idea that Apple needs to help its rivals out and help them get through and compete better. But there's a good pro-competitive reason for not doing that, which is, let's take the Apple Watch, for example, right? Their argument, the DOJ's argument being, you're just not putting this on an Android to increase switching costs. Well, Apple's argument is, hey, well, we don't want to put this on an Android device because they aren't as secure. Maybe customers are going to get their data collected on the phone. They're going to maybe lose some of that data, privacy breach. Now we hit a reputational harm. At the same time, if we're limiting the Apple Watch to the iPhone, that means like Android devices need to build up better watches, better smartwatches. That gives consumers more choice. And there's a pro-competitive reason for a lot of what Apple is doing, and they're going to assert these pro-competitive justifications. Let's go to the green text bubble. One of the reasons you want to have a green text bubble is to say, look, we can't integrate all our security features that we have on iMessage into a general SMS text message over the network to a different device. We are giving you the green bubble to let you know, hey, you don't have these same features, so be aware of that. And that's just a consumer benefit that also makes it so Android devices need to continue to improve. And again, there's a lot of competition right now on the fact that this is a closed market. This is a closed platform. Some consumers like that. Some consumers don't, and they go with the Android because they can get more of that open approach here. And that's just something that I think we need to pay attention to as this case goes forward, is that there are a lot of pro-competitive reasons for the things that Apple's doing, and if they can convince the courts of that, they that'll be a very good outcome for them.
Yeah. So why now? I mean, why is the DOJ making this case now? Apple iPhones have been incredibly popular for such a long time, and the Apple Store has been around a long time. I mean, I think I've had it since I was in a form of it since I was in middle school or something like that. What's changed?
Yeah. So I wouldn't say a ton has actually changed. I think the more interesting thing is just kind of the bigger, negative view of the App Store practices. Obviously, they're not necessarily going after them directly here because they're focusing on the smartphone market. But after Epic lost that case, I'm kind of speculating with this, but I would assume that maybe the DOJ thought this might be a good approach, and then after the case lost, like, all right, we need to kind of transition here to go after some of these practices. And obviously, it's made a lot of headlines, right? You've got the 30% fee to get to the App Store or for transactions in the App Store, and a lot of companies who are paying that fee don't really want to. There's, just to give an example, I've been playing a smartphone game, which Star Wars Galaxy of Heroes, you collect cars and whatever, but there's a lot of microtransactions in these mobile games, and if you're just thinking about like maybe there's a $10 bundle, a $20 bundle, you're paying 30%, or Apple's getting a 30% cut of all of that, right? And so those companies are losing. I wouldn't say losing because they're gaining a lot of benefit from being on the App Store, but they're spending a lot of money that could be, back in their pockets if they can get the laws changed or if they can win some of these antitrust cases. So they've been making a lot of public arguments saying that these 30% fees are too high and they're harming consumers and they're harming developers. And I think that's propelled a lot of this into the news that historically hasn't been as much of an issue. And
Gotcha. Interesting. Do you think some of that would be taken care of if, like you said in the earlier that if they broadened and Android continues to improve, would some of those and there's more competition for playing those games, would some of that be alleviated through that, or is it hard to say?
It's hard to say. I think if more people were on Android devices, maybe you could get around some of the fees because you can install different app stores and whatnot. But you also have to remember that these game developers are gaining a huge customer base by being in the App Store. And there's a lot of benefit from being in the App Store, which is it comes with a lot of assurances to consumers that like, hey, I trust the security and integrity of the App Store. So a lot of that is transferred onto your app because it's in the App Store. It's been approved. It has all that. And also just wide customer base, right? And if you're high up in the App Store, you're getting more and more customers. So it's a mutually beneficial relationship. But every company here, Apple, the app developers, whoever, obviously want to maximize profits. So if they can show that Apple's 30% fee or whatever is harmful to competition, maybe they can get that fee lowered and they can make more money. And again, that's not really the focus of this case, but it's kind of underlying all of it. And I think that that's why it's so in the news, because like obviously the case is focusing on smartphones, but if they can, break into some of those different Apple products and open them up. The DMA in Europe, we've talked about, you and I've talked about this. It's kind of beyond the scope of this podcast, but Europe is kind of forcing Apple to open up their system and trying to get around some of those fees. So it's just propelling a lot of this into the news. So even though it isn't the focus of this case, it's definitely kind of underlying it.
I think the Digital Markets Act is definitely a podcast in and of itself.
Oh,
so
we
don't even touch that one today.
I didn't even explain the acronym. Thank you for saying the Digital Markets Act in Europe.
Yeah, it's part of their whole technology thing, which we could do a whole podcast on Europe in technology.
We got to do a golf one before that.
Yeah. That's coming up soon. I think that's a good one for Around the Masters. This is usually the time in the podcast though that I ask Doug a really hard trivia question.
Oh boy.
But I'm not going to do that to you today.
Good.
So
Let's do a Star Wars trivia or NBA history. I don't have a lot for you.
So I'm giving you a pass on that. But this is my moment where, throughout the entire podcast, Doug answers all the questions, but it's my turn to act like I know something that he doesn't. So that's always a fun part for me.
So now you're just telling me this and not letting me participate. Now I feel you're leaving me out of the fun here.
Yeah. It's maybe next time I'll surprise you with one. So I'm trying to get you off balance. I'm playing a longer game.
How about who did the Celtics lose to last time?
Oh, really? We have to do this?
They play again tonight.
Yeah,
it's great.
We've clinched playoff. The playoffs before anybody else has clinched the playoffs. In the bigger picture, Monday's loss means nothing.
I keep derailing this, don't I? We'll stay focused for the end here.
Yeah. All right. We have two more. I have two more. One last topic I want to cover, and that's the broader implications of all of this, because obviously it fits into a larger market. It fits into a larger policy objective. Basically, what are the larger implications of all this? The Biden administration has certainly been very outspoken on this issue. How does this fit into the broader trend against antitrust?
Well, so it's not against antitrust per se, but against some of these companies.
Right. Sorry, yes.
Yeah, but I think the bigger trend to keep an eye on is just that there's this push that says concentration in markets is bad, and we should try to prevent that. And when we were talking about a lot of the pro-competitive justifications, that's the exact opposite side. That's saying there's concentration, but there's a lot of reasons that's a good thing. There's efficiencies that are created. There's incentives for other companies to improve their own products and services, so it raises the bar for everybody, and consumers are better off. So I get worried with some of the approach where it's saying concentration's bad, because I just don't want to lose sight of the benefits there. I think this case is really interesting because it's not really a novel case. There's a lot of old theories of tying, of duties to deal. All these things have kind of been evaluated a lot in the courts, and obviously the facts here are going to matter a lot, so they're going to have their economic experts, they're going to argue all these points, but I think the legal theories themselves aren't that new. And so it's interesting because if the courts are more amenable to them, they're more willing to accept these arguments, that might be an indication that, hey, this big is bad approach may be gaining traction in the courts. Because right now it's really gained traction in the Biden administration and honestly some of the public conversations about antitrust. But I don't think the courts have really bought it yet.
Yeah.
So this is one to watch to see kind of how the DOJ does and see if courts are more willing to say, okay, because back on the duty to deal, I said there's no duty to deal, but there are cases out there that say, well, in some cases, you know, Aspen skiing's the big one where essentially a ski operator used to work with another one up in Aspen. There's a couple different mountains, and they just were like, we're not going to work with you anymore. And they went so far as basically not to take vouchers that customers had already had. So it was basically free money that they were saying, no, we're not going to do because we don't want anyone else to go to this rival thing. And they're like, no, in that case, you have to, you know, you're being anti-competitive here. So there are cases like that out there that I think courts could build on and say like, yeah, I know a lot of the existing precedent is saying there's no duty to deal, but we can distinguish that. This is more like the Aspen skiing case, and therefore start expanding some of the theories there. So that's the key for me, is just to see how likely courts are to start accepting some of this.
I know there's, you know, what about on the other side there? Is there anything, like we've had a couple of cases in this already, is there stuff that they could pick up, that Apple could pick up on, like previous cases that would say, you know, this isn't antitrust behavior kind of thing? Like,
I think the big thing there, it's a great question. I think the big thing is the market definition side of things, because the interesting thing that the Epic case essentially said was that Android and Apple, the iPhone, are competing, and that is and that was something that Epic tried to get around, saying no, they aren't actually competing. It's just Apple. That's why we're stuck in this app store. Then Google or Android, I guess, lost a case essentially arguing the same thing, even though they have an open platform. They were saying no, you don't actually compete. This is a distinct market because it's not substitutable. So I think the interesting thing from Apple's perspective is to just kind of point to its old case, saying, look, we're vigorously competing with Android still. We don't have monopoly power. The court has already said that, and kind of building on that idea, just to show that like these tech markets are complex and confusing, and they're tough for courts to handle. There's a lot of competition throughout the stacks. I tend to think that prevents them from extracting monopoly power or extracting monopoly rents and exerting monopoly power, but that's an interesting question.
Yeah.
Where in the stack is there monopoly power? Are you using that to help yourself in other areas? Does that violate the law?
Interesting. Yeah, so there, I mean, one of the things that stood out to me in that FTC event we did was, I can't remember who made the point that some of these cases that they've brought, and it might not pertain to this specific case, but that have just been weak in general. So, and that could play a role in some of this. So it's always interesting to me to see how, if any of that's going to play a role.
Yeah, I think that's obviously a really good point as well. I've seen a lot of commentary saying this is a weak case. I tend to agree. I thought they would go after the App Store, to be honest with you. I thought they'd do similar stuff to what Epic brought. I think that's a more believable case of monopolization if you can exclude the Android devices and saying like, no, App Store is its own market, because then it's like, okay, yeah, they do control it, but that's the whole point of it. But no, they went with the whole monopoly of smartphones, and I think that's a tough one to prove. I think it's going to be very tough for the DOJ, but it's going to rely a lot on their arguments about restricting switching, and if they can say like, actually no, you can't really switch, and people are I think it's like 10% of people are buying new smartphones, so it's like, how do we get into that 90%?
I mean, speaking of Apple users, I mean, I'm an Apple user, you're an Apple user. I'm very much in the Apple ecosystem. My computer is an Apple, my watch is an Apple, my phone is an Apple.
You're hurting Apple's case here, Dal.
I like it. It's my choice, and I've chosen to use them. I love being in the Apple ecosystem. I don't want to be a shill for Apple here, but what does it mean?
You're doing a great job.
What does it mean for Apple users, though? I mean, if this case is successful.
So I think the thing for Apple users, immediately, it's not going to affect Apple users a ton immediately, but over time, we're going to see a lot of different restrictions kind of put in, and a lot of unfortunate barriers that you don't have now that are just going to make the experience less streamlined, less optimal. It also depends on what the DOJ seeks. Like, maybe they could say, okay, you have monopoly power because you're restricting the ability for iWatch or Apple Watch to go to Android devices. Maybe they try to force Apple to divest part of their business or something. But I think the more practical, the more likely outcome is if the DOJ wins, is we'll see a lot of the same things we're seeing in Europe right now, which I know we brought up the DMA, but that has gone into effect, and a lot of the gatekeepers, as they're defined by the law, are starting to implement the features, and a lot of consumers are complaining because there's additional notification menus, there's additional pop-ups, like if you were buying an iPhone, you would have to scroll through a list of web browsers and say, I want to use Safari, I want to use Chrome, whatever, before you could even start using the device. It's not coming pre-installed. A lot of those types of things are going to get taken away, and it just makes the user experience a little bit worse. But at the same time, if you're an Android user who wants to use an Apple Watch, maybe that's a benefit for you. Now you're able to use the Apple Watch and use that with an Android device. Maybe the text messaging on the SMS is a little better. I also crack up at that SMS one because it's not like we don't have WhatsApp or Discord or whatever other messaging
100
app.
different other messaging apps out there.
Maybe you just should use one of those if that's such an issue. But regardless, that is the kind of thing that consumers are going to have to think about, is just a lot of this is going to add frictions to their experience.
Interesting. Yeah, I mean, I think you mentioned the scroll down thing, and to choose one, you have to scroll all the way to the bottom, right? You have to
so it's interesting. So that's not what the compliance plan is, but it's
okay.
The DMA filed these investigations, I think, last week. So this is really new development, and so I don't know exactly the details, but it sounds like the Europeans are saying, like, yeah, you need to scroll all the way to the end, or else it's not really an informed choice, because they're really there to protect competitors rather than competition. And we can talk about this a whole other podcast, but
we won't get into the weeds on that for now. But Jeff, thanks for joining us. This was a great conversation. I think I learned a lot about this whole. I'm not a legal expert. I don't have a law degree, so it was good to sit down and talk about this to get sort of the basics on the subject. I know you have an insight either out or coming out on this topic.
It's out as of this morning.
So we'll include that in the show links. Obviously, if you have anything else that you'd like to let our people to highlight, then we'll include those links as well.
Great. Thanks for having me.
I hope you enjoyed this conversation. Tune back in for our next episode, where our experts will provide clear, data-driven insights into today's economic and domestic issues. I'd also encourage you to check out any of the links in our show notes, and also follow us on social media to learn more about AAF. Don't forget to subscribe on iTunes, Spotify, or Google Play.